Hello students. So in the last session we have discussed about various types of companies. It may be called as classification of the companies, or the question may be asked in the exam as kinds of the companies, so your answer should remain the same. Okay, so there are almost 14 to 15 different types of the companies we have studied. Okay, so question is expected in the short notes. Directly the company can be asked in the short note, or the full question can be asked on the types of the companies. So today we are going to have the discussion on various distinguished betweens which may be asked in the exam. So first our focus will be on, we will try to make the differentiation of the company with various other forms of entities. Okay, so we have already studied, okay, in the first lecture various forms of entities. So what we are going to do, we are going to study company versus, first we'll talk about partnership firm, then we'll talk about limited liability partnership, and then HUF. Okay, in such a way we will try to understand. So one by one, let's get started. So the first point of difference, let me just put, so we have bifurcated this page into two. So first we will talk about company versus partnership firm. First let's talk about company versus partnership firm. So we will try to understand these differences, okay, with various headings. Okay, the first point of difference can be with respect to governing law. The first point of difference can be with respect to governing law. So company form of business is governed by which particular act? So company form of business, it is governed by Companies Act 1956 or 2013. Because I have mentioned 1956 because few companies, those which are registered under 1956, are also recognized under this law. Here you can write down, it is governed by Indian Partnership Act 1932. As we know, we have Indian Partnership Act 1932, by which this particular partnership firm business is regulated or governed. Then the next point of difference can be mode of creation. Mode of creation. So how company form of business gets created? It is by registration. So always remember students, it is only by registration of a company form of business can be created. But what about the partnership firm? It is by an agreement. So normally this agreement is called as the partnership deed, where the partners, they decide their mutual rights and liabilities. Okay, they can decide about the remuneration part. They can decide the implied authorities between the partners. So everything is governed or regulated by the agreement. There are some provisions in the Partnership Act also relating to the agreement. Then let's talk about topic liability. This topic we have discussed in depth, okay, in during the last lecture. If you remember, when we have discussed about the types of the companies, we have discussed about the various types of the companies based on its liability. How is the liability in case of company? It is limited. Normally it is limited only. As I told you, unlimited company is there, but it is not so popular in India. And how is the liability in partnership firm? It is unlimited. It is unlimited. So I can just say it is limited and unlimited. What does it mean? So when there is a kind of liability in the partnership firm, partners' personal assets are also liable. But what is the liability? Is it limited by shares or limited by guarantee? So there can be two types of limited liability. It is limited by shares to the shareholding, to the extent of the shareholding of the shareholder, or to the guarantee. Okay. So the guarantee which has been undertaken by the shareholder under MOA, that is Memorandum of Association. Then next talk about minimum number of members. Minimum number of members, or I would say partners. So what you can do, you can give the numbering to all these points. This is 1, this is 2, this is my third point, this is my fourth point. Okay. So how many minimum number of members do we have in the case of partnership? There are in the case of company, there are two types of companies. Okay. So first, let's talk about, we can bifurcate into 2, 3 also. One is OPC. So of course we require minimum 1. Then private limited, we require minimum 2. And in case of public limited, we require minimum 3. What about the partnership firm? In case of partners, okay, so these are the number of members we require. Okay, these are the number of members. Let me just clarify this point. What is the difference between members and shareholder? Shareholder is a person till the time his name is registered under the register of members. Okay, he will be called a shareholder. But once his name is registered under register of members of the company, he will be considered as the member. So we require minimum 2 members, I think I have made some small error over here. Minimum 7 members. Okay, minimum 7 members in public limited company. Okay, so 3 categories of company I have given: OPC, that is one person company, private limited and public limited. What about the partnership firm? How many? We require minimum 2 partners. We require minimum 2 partners. Okay. Let's try to understand. We have covered almost 4 points. Let's once again try to understand. Company, and we are talking about partnership firm. So the next point of difference can be maximum. So point number we can say 5. Maximum members और partners. So कितने लगते हैं maximum members और partners? maximum. So in case of OPC there is no, okay, maximum also is 1 only. So we can say OPC, there is no change, minimum maximum 1 ही लगेगा. Private limited, in case of private limited maximum 200. In case of public limited maximum no limit is there. So there is no upper limit in case of, okay, public limited company. What about the partnership firm? Okay, when a partnership firm is carrying on the banking business, students, when it is carrying on a banking business, the maximum limit would be 10. And if it is carrying on any other business, then maximum limit would be 20. For banking business maximum कितना रहेगा? 10 रहेगा. See here we are talking about maximum. For any other business maximum would be 20. So these are the limits. Please, students, most of the times what I have observed, okay, students write down answer 50 in case of the private limited company. It was the earlier limit as per old act, but as per new act which is defined under section 2 subsection 68, the definition, the limit would be 200. Okay, so कितने points हो गए हमारे? 5 points we have covered. Transfer of shares, 6 point. Transfer of shares. So can there be restriction in case of company for the transfer of share? There won't be any restriction. So I would say no restriction. And what about here? Yes, there would be restriction. If you remember, when we have studied about the private limited company transferability, there can be some restriction laid down. But restriction in the sense, the shares can be first the existing shareholder can first approach the other shareholder before approaching the outsider, and if he denies to purchase, then only he can go to the outsider. But here the total restriction can be laid down under partnership form. Let's talk about registration. So whether it is compulsory under Companies Act? Yes, it is compulsory. So I would say it is compulsory. What about here? It is not compulsory, so it is optional. Optional, but okay, but registration is compulsory in Maharashtra, in state of Maharashtra. So when we are talking about Maharashtra, it is compulsory. So registration is optional in case of partnership firm. So in case of partnership firm, okay, there are various disabilities given to the partnership firm which is not registered. So non-registration will come up with various disabilities. That is not the case with the company form of business. Next point of difference can be common seal. Recently there is a provision which regarding common seal, okay, the relaxation is given, okay, but it is compulsory, we can say, and most of those companies still they follow the common seal. It is not compulsory. But yes, there are some relaxation given with respect to the common seal, okay, as per MCA notification. So still one of the point you can add in your notes. So many points of difference you can identify. company. Still we are doing the first thing only. Partnership firm. Company, partnership firm. Okay, in the previous we have completed 8. Now let's talk about the 9th one. 9. Meetings. So meetings are compulsory or not? Yes, compulsory. And here you can just put that no such requirements. No such requirement. When I say compulsory, which types of meetings are compulsory? For example, okay, I can just mention over here, BOD meetings are compulsory. Then general meetings can be there. Okay. So general meetings are divided into, there can be audit committee meetings if the specific or specified company is there. So such requirements are there in the case of the company form of business. Next point of difference can be perpetual succession. So whether company enjoys perpetual succession? Yes. Partnership firm? No. So perpetual succession means going concern. So company is a going concern. From time to time we have studied this particular concept. Compliances कैसे रहेंगे in case of company form of business? There will be more compliances. But what about partnership firm? Less compliances. Why? Because Companies Act is a very lengthy act. So there will be very more compliances. Here there will be less compliances. Because it's a very flexible form of entity, partnership firm. Partners can decide what they want, what they do not want. But they cannot just deviate from the general provisions of the Partnership Act. And the last point of difference can be audit. So audit requirements, whether it is compulsory? Yes, it becomes compulsory in case of company, and it is not compulsory. But whether it does it mean that partnership firm accounts audit should not be conducted? It is not like that. After certain threshold, partnership firm also has to undergo the audit process. But that is not the case with the partnership company form of business. It becomes from day one the audit requirement becomes compulsory, and they have to undergo the audits from periodic basis. So these are some of the point of differences. Please make a note of it very quickly. So first point of difference, we have talked about the governing law, then mode of creation, liability, minimum number of members and partners. Just make a note of this particular question. Next page, maximum members, partners, then transfer of shares, registration, common seal. Next, we have discussed about meetings, perpetual succession, compliances, and audit. So this question can be expected for the short notes as well as full length question, because there are so many points as you can see over here. There are almost 12 points we have written. So question can definitely be expected. There can be few more, like contract cannot be entered into by partnership firm directly in the name, but company can enter into such contract. So such type of differences also can be added, one or two. But these are the major point of differences one should know. Chalo. So let's proceed with our second. So we have completed so far company form of business versus partnership. Now we'll try to complete LLP. Let's try to complete LLP. So company versus limited liability partnership. In short, it will be called as LLP. So let's try to understand. The first point of difference would remain the same, like governing act. So which is the governing act? What you would say? It is governed by Companies Act 1956 or 2013. What about this? It is governed by LLP Act, that is Limited Liability Partnership Act 2008. So this would be my first point of difference. My second point of difference would be name. So it must contain you can say suffix So what kind of suffix it must contain? If it is a private limited, then private limited, privity limited. If it is a public limited, public limited, or limited. So this is the kind of identification for a company, so that the outsider will come to know it is which type of company. It must contain suffix LLP. So students, okay, in case of the private limited company, private limited, full word can be there. Public limited also full word can be there, or you can just use PVT limited, private limited. In case of LLP, it can be limited liability partnership as well as LLP. So it can be either of it. Again, see, there are various point of differences which are similar, like common seal. Whether it is compulsory, yes. It is compulsory, but as I told you, in case of the company form of business, okay, now the relaxation has been given with respect to, but we don't know how long it will last. That is the reason, okay, I am mentioning this point. So it is optional. It is optional. So organization structure, how you can say organization structure. So one can say that, okay, it is rigid. It is rigid and governed by Companies Act. But here it is flexible and governed by LLP agreement. LLP agreement. Okay. So in case of the company form of business, it is little bit rigid in nature, but in case of, okay, LLP form of business, it is flexible, because there is a kind of LLP agreement. Similar is the case with the partnership firm. Partnership may have its own partnership deed, okay, through which they can decide the rights and duties, liability, everything can be decided. Similar is the case with the LLP form of business. So LLP form of business contains mixture, or it contains various features of the company form of business, and it has borrowed various features of the partnership form of business. Let's again try to understand. So we are talking company versus LLP. So how many point of difference? 4 we have completed. Let's talk about fifth one. Fifth one is again minimum members partners. So what is the minimum? Okay, we have studied under OPC we have seen 1, under private limited we have seen 2, and under public limited we have seen 3. What about the LLP form of business? Under LLP there are minimum 2 partners required. There are minimum 2 partners required. What about the maximum limit? Maximum members partners. So maximum can be, in case of OPC again, okay, when we say OPC, okay, OPC again it will contain maximum 1 only. It will remain the same. Private limited, as we have studied under the partnership difference also. Public limited, there is no upper limit, no limit. What about the LLP? Maximum. So it is very similar to the public limited, no limit. So this is a major point of difference, okay, like in case of partnership firm, there is a limit defined. So partners, those who want to keep maximum number of partners, may go for the LLP form of business. So this is one of the very important point of difference. Capital structure. So in case of the company form of business, it is little bit less flexible I would say. It is flexible. What does it mean? Like in case of the LLP, the capital structure is in the form of contribution. Now contribution definition is defined under the LLP Act, and as per that the capital contribution can be made. But here it is the less flexible because there is a proper process to be followed. Okay, after following that process only there are various types of capital. We have authorized capital, paid up capital, called up capital. We need to, okay, under the Companies Act, okay, one has to go with that particular flow only. So it is less flexible in nature. So what can be the capital and all that? Meetings. Whether meetings are compulsory, as we have seen, the answer would be yes. The meeting should be compulsory in case of company form of business. So no such requirement, we can say, no such requirement. No such requirement. Company versus LLP, we are trying to understand. So how many point of differences? I think we have covered 8. Yes. So let's talk about the 9th one. Compliances. So here we can say there are more compliances. So you can find most of the points are similar point of differences between, as we have studied under company versus partnership. Less compliances. There are less compliances. Again, talking about the audit requirements. Audit requirements. Is it compulsory? Is compulsory. When we talk about that, not compulsory. So in case of LLP, again the similar provision is after you cross that threshold, the audit becomes compulsory. That is not the case with the company form of business. One more last point of difference I can add about the decision making. So who looks after the management of the company form of business? So we require minimum 2 directors in private limited and minimum 3 directors in public limited. What about the LLP form of business? See, there is a concept called as designated partners. Okay, so under LLP also minimum 2 designated partners are required. Partners are required. So कितने partners लगते हैं? 2 designated partners. यहाँ minimum 2 in private limited, minimum 3 in public limited. So these are the main point of differences between company and LLP. So please note it down fast. So first point we have to talk about governing act, then name, common seal, organization structure. Then we have talked about minimum members, partners, maximum members, maximum partners, capital structure and meetings. Then we have talked about compliances, audit, decision making. Okay, I hope you have completed. So now let's quickly go and discuss about the small distinguish between which is there versus company versus Hindu undivided family, which we can call it as HUF. Okay, very quickly we'll try to understand the same. So let's try to understand type of members. The first point of difference would be type of members. So one can say that company consists of heterogeneous members. It consists of heterogeneous, okay, members. What is meant by heterogeneous? So there are variety of members, okay, or you can say the diverse can be the proper word, diverse members, okay, in case of the company form of business. Here you can write down it consists of homogeneous members. Since members belong to family only. So HUF में क्या होता है, members are from family only, and that is the reason they are, okay, homogeneous members. And in case of company, there can be diverse members can come together and can start the business. Okay, let's talk about the second point. Here we can call, there are not many differences, but let's try to understand few of them. So if the question is asked, you should be in a position to write down the answer. Okay, there is no system of authority given in the case of company. There is no system of authority given under company. But what is the case over here? In case of HUF, the karta karta, who is also called as manager in for the HUF business, as the sole authority, as the sole authority. Okay, so karta के पास पूरा authority दिया है, but here there is no such system which is given to one particular person. So we may have shareholders, they can take different types of their decisions. The board of directors can take different types of decisions. How a person becomes member in the company and HUF? By birth, can it be possible? It is not possible. It is not possible in case of company. It is not possible. So one has to rigorously follow the procedure laid down under the Companies Act to become the shareholder. Either it may be in the he may become shareholder by transfer, transmission, and so on. But here a person becomes member by birth. So कैसे member बन सकता है? By birth से, but it is not possible. Last point of difference, I think there is no space, so I would say I can take. Quickly we can write down company versus HUF. Okay, so fourth point of difference can be registration. So whether registration is compulsory in case of company form of business? Yes, it is compulsory. What about here? It is not compulsory. It is not compulsory. So it is compulsory, it is not compulsory. Okay, so these are the four major point of differences I can find out. Okay, there cannot be many more. Very rarely the question can be asked, but you should be ready with the answer. So you can just write down the answer very quickly. Types of members, authority, by birth. Then registration, whether it is compulsory or not. So that's it. Here we have completed the business, the company versus various business entities. One more question which I would like to complete today itself, the difference between, let's quickly complete it, difference between private limited and public limited. The difference between, let's say, private company, question is can be asked, versus public company. Private company versus public company. Okay, so the difference we can start this particular difference with the definition. Okay, where it is defined, private company under section 2, 68 of CA 2013. Okay, here it is defined under section 271 of CA 2013. So whatever definition is given for the public limited and private limited, you need to write down. So what is private limited? It is a company. It means a company which can restrict the number of members to 200, which can restrict the transferability of the shares, as well as which can prohibit the invitation of shares to the public. Public limited company, which is not a private company, and it can require some minimum paid up capital as per the rules as may be prescribed. Then you can talk about minimum members. Minimum members कितने लगते हैं प्राइवेट लिमिटेड में? Okay, minimum you require 2 members, and here you require minimum 7 members. Then you need to write down. Okay. Then one can talk about maximum member. मैक्सिमम कितने लगते हैं मैक्सिमम मेंबर्स? मैक्सिमम अभी तक तो आपको याद आना चाहिए, मैक्सिमम 200, and here maximum no limit. So one can have 1 lakh members also, no limit is there in case of public limited company. Okay, so here you can put one more point of difference. Minimum directors. Minimum directors कितने लगते हैं minimum directors? Minimum 2 directors are required. Minimum 2 directors. Here minimum 3 directors are required. Minimum 3 directors are required. Okay, to start a company you require first directors, minimum 2, minimum 3. Okay, so without having these particular limits you cannot commence or you cannot go for the registration. So there is a process laid down under the Companies Act for the registration or incorporation of a company. So in that particular chapter we are going to talk about the entire registration process. So how one can go for the company form of business, how it can be registered, which all documents are required, and so on. Then let's talk about invitation to public. Invitation to public. Can a private company go and invite public? It is not allowed. But can public company and go and invite? Yes, it is allowed. So here we can say it is not allowed. It is not allowed. And here it is allowed. So definitely public limited company, the name itself says that company can go, public limited can go to the public and can raise the capital as per its requirement. But that is not the case with the private limited company. Private limited company has been restricted because it is given under the definition itself, under section 212 subsection 68, that a company cannot go to the public. That restriction has been laid down. So 5 differences we have studied. Let's talk about the other point of differences. prospectus. The prospectus is required. See, what is prospectus? Prospectus is a document through which, by issuing the prospectus, one can go and invite the public. So when a public company is going to the public to raise the capital, the proposed shareholders or the proposed security holders should be aware about the prospectus, should be aware about the information where the company is going to invest those funds. But in case of the private company, the private funds are involved, and that is the reason there is no requirement of issuance of prospectus. So what you can say, it is not required. So I would say issuance of prospectus. I can add one word over here, issuance of prospectus. So whether it is required? No, it is not required. Not required. So whether it is required? Yes, it is required. So public limited company has to issue the prospectus. That is not the case with the private limited company. Next point of difference can be name of company. Name of company. Name of company, it should end with private limited or PVT limited. It should end with either private limited or PVT limited. So normally आपने देखा भी होगा कुछ कंपनीज को प्राइवेट लिमिटेड एंड पीवीटी लिमिटेड, ABC private limited or ABC PVT limited. So here it should end with public limited or with just the word limited. That is also sufficient. That is Reliance Limited, Reliance Industries Limited. So one comes to know that it is a kind of public company, not a private company. In 8 point of difference. The previous, how many points we have completed? 5 years. Can be transfer of shares. Transfer of shares. Can restriction be let down in case of private company for the transfer? Yes, it is yes. So you can say restriction can be laid down for transfer. Okay, transfer of shares. I can just complete this sentence, transfer of shares. But here shares are freely transferable. Shares are freely transferable. So there cannot be any kind of restriction. Shares are freely transferable, but here restriction can be laid down. Can add 2 more point of differences. Let's add it in the next page. So far we have completed 8 points of differences. Yes. ninth point can be managerial remuneration. Managerial remuneration. So provisions of managerial remunerations are not applicable. Not applicable. See, there are provisions in the Companies Act about managerial remuneration which are only applicable for public limited companies. What is managerial remuneration? So like if a person is the managing director of the company, how much maximum managerial remuneration he can get. If board of directors have there, how much maximum remuneration they can get as a body. So that is the limit prescribed, specified under the Companies Act. That is only applicable to the public limited company, not to the private limited. Because since the public funds are involved, one has to be very careful while giving the remuneration. But if private funds are involved, they are only interested. Of course, why one should do the business and invest money in the private limited company? Because the person is interested in getting the return on it. So managerial remuneration concept is not applicable to the private limited company. What we can say, compliances. So of course there are less compliances compared to public limited company. There are more compliances compared to private limited company. So which types of compliances can be more or less? Like in case of public company, SEBI may come into picture, listing agreement provisions may come into picture. Companies Act is always there to regulate the business. There can be more number of audit committee meetings and so on. But here in partnership, in the case of the private limited company, there cannot be the listing agreement provisions, there cannot be the SEBI provisions required. Only the Companies Act is there to regulate the business of the company. So, of course, when there are less provisions, you will have less compliances, and when there are more provisions, you will have more compliances. So, these are the major points of differences. Sometimes in the notes you will find one more point of difference, but it has been dispensed with. But I can still mention that. Like minimum paid up capital. In notes you may find it, but this has been dispensed with. Through rules. But earlier also 10-15 years back, government had removed it. Again it was reintroduced. Again it was removed. So what is the minimum paid up capital requirement? Minimum rupees 1 lakh, and here minimum rupees 5 lakh. So अगर आप लिखते हो नहीं लिखते हो तो भी कुछ फर्क नहीं गिरेगा. No problem with that. So that's it. Please note down all these points very quickly. So we have talked about definition, minimum members, maximum members, minimum directors, invitation to public. Issuance of prospectus, the name of company, how we should end with, transfer of shares provision, managerial remuneration compliance. One more point of difference I am quickly going to add, that is independent director. So whether independent director is required in private limited company, not required. But here it is required. So this can be also one of the point of difference. So managerial remuneration compliance, minimum paid up capital, independent director. So independent director, because public money is involved, one neutral person who is not connected with the company as such should be there as the independent director. Private limited में जरूरत ही नहीं है, because private parties are going to run the show. So these are the major point of differences. So students, we have completed today 4 difference between questions. The first one was we started with the company versus various forms of entities, business entities, company versus partnership. So this was my first question. Then we talk about company versus LLP. Then we discuss about company versus HUF. And finally we discuss about private company versus public company. I hope you understood all these provisions very well. Do watch this video and please go through the provisions carefully. Thank you so much for attending this session. Till then, goodbye.